Prosecutor Eric Smith on behalf of the people.
Good morning, Your Honor. Dean Ancuni appearing on behalf of Mr. VanCallis.
Very well. The officers are bringing in Mr. VanCallis any moment.
I thought it was the 12th. I thought it was this Friday.
No, it's the 20th.
Okay. All right, then we have time. But the jail told us Friday. Yeah, jail told us tomorrow.
No,
Okay.
20th.
Mr. VanCallis, I'm going to have you stand right up there next to your attorney. Mr. VanCallis, want to give us your name and address for the court record?
James VanCallis, 8744 Marquette Road, Goodalls, Michigan, 48027.
Mr. VanCallis, I want to advise you that you're charged on or about July 24th of this year in the village of Arraignment, Macomb County. Count 1, homicide, murder in the first degree. That is with premeditation of April Millsap. That is a felony punishable by life in prison without parole. Count 2, homicide, felony murder. That is a felony punishable by life imprisonment without parole. At the same date, time, and place, you're charged with count 3, criminal sexual conduct, assault with intent to commit sexual penetration. That is a felony, potentially punishable by up to 10 years in prison. Do you understand the nature of the charge?
Yes.
You have an absolute right to be represented by an attorney. Enjoy Mr. Antoni's appearance today on your behalf. In the event that you're unable to afford an attorney, you economically qualify, the court would appoint an attorney to act on your behalf. You have a right to a trial in this matter before the court and before a jury. You also have an absolute right to remain silent. Anything that you say, orally or in writing, could be used against you in court. You would have a right to have Mr. Antoni present during any questioning that you might consent to. You understand those constitutional rights, Mr. VanCallis?
Absolutely.
Mr. Antoni, how is Mr. VanCallis pleading?
He's standing mute, Your Honor.
Very well. In motion, he stands mute. I'll enter a not guilty plea on his behalf. Mr. VanCallis, one of your very important rights as a Michigan citizen is that of a preliminary examination on these felony charges here at the district court level. At that preliminary examination, it would be the burden of the people, with the prosecuting attorney, to establish probable cause to believe the crimes have been committed and they've been committed. If the prosecutor carried that burden of proof, then this matter would move on to the circuit court in the county seat of Mount Clemens for trial. Do you understand that?
Absolutely.
Very well. That's to be settled in 14 days.
Your Honor.
Including, we should note at this point, we did have a chambers conference prior. We discussed scheduling with our calendars all out. Is there a waiver of that 14 days?
There is, Your Honor. I personally discussed with Mr. VanCallis what a preliminary examination is and the fact that he can have that examination within 14 days. He is voluntarily waiving that right to have it within 14 days.
Is that correct, Mr. VanCallis?
Yes, it is.
All right, I'm satisfied. I'll accept the waiver for 14 days. Now, one of the things we discussed with our calendars all out in front of us was scheduling on this, and we have my chief administrative clerk in with us, and we have decided, are we all in agreement that this is appropriate for a pre-exam conference, given the amount of evidence, documents, all those things to be gone through, to be given to the defense, that would be the most appropriate way to proceed here, to set a pre-exam conference?
Yes, sir.
We do, Your Honor. I would like the record to reflect that I am anticipating an enormous amount of evidence in this case. And if in fact, when we come back on the conference date, if I'm not fully prepared at that point, based on the amount of evidence, I would possibly be requesting another conference date after the date
Well,
of November.
I understand that. But let's see how things go. I know I've got very good counsel here on all sides, and I expect every effort to work hard and get all of that done. What I'll want at the pre-exam conference is a report as to how that exchange of documents, discovery of course we call it, how that stands. So we will review it at that point. And we did come up with a date that was agreeable with all counsel and the court. And of course, our pre-exam conference is going to be a Thursday afternoon.
Thursday, November 13th.
Thursday, November 13th. It'll be at 1:30 sharp, gentlemen. All right. And I did want to set my understanding, Mr. Cataldo, is that you anticipate the examination to be perhaps 2 days.
Yes, sir.
So court needs to set, and be careful how it sets it. I have otherwise busy dockets. We also have set aside 2 days in December for this examination.
Monday, December 15th, and Tuesday, December 16th.
Very well. Now, we will discuss, of course, where this all stands at the time of the November 13th pre-exam conference. I do want to address the issue of bond here. Who wants to speak on behalf of the people? Mr. Smith?
Your Honor, I would, don't tell on behalf of the people. We know that Mr. VanCallis has had numerous contacts in this community with law enforcement. This is, as the investigation has shown, a violent, senseless, and most likely random act that has shaken the confidence of this community on that trail. Law enforcement has done a wonderful job to do an investigation and make an arrest in this case. Based on those elements, Your Honor, we would ask that no bond be set as allowed for heinous crimes under the statute. We believe that this type of charge or these charges qualify, and we would ask this court set no bond in this matter.
Mr. Green?
Mr. VanCallis has lived his entire life in the state of Michigan, Your Honor. He has ties to the community. He lives within 20 minutes of the courthouse. He obviously wants to see these charges come to the appropriate end. He has retained counsel. He's treated this matter seriously with myself and with his entire family. We all believe that he will return to court at each and every court date if he is given a bond. We do understand the seriousness of the charges. However, we don't want someone's life completely destroyed if this case takes an enormous amount of time to come to its final conclusion. We do believe that it could be some while before there is a trial in this case. And if Mr. VanCallis is found not guilty of these charges, he will suffer irreparable harm at that point by being in custody for a very long period of time. We do understand that Your Honor is inclined to have a high bond or no bond in this case, but we would ask it to be simply a high bond. So in the event that Mr. VanCallis can post a bond, even if it's on some type of GPS tether, so his activity and whereabouts can be monitored, that would ensure to the court that we know where he is at all times. But that would also mean that in the event that he is found not guilty of this crime, and he's presumed innocent right now of this crime, so if he's found not guilty in the end, we don't want him to go ahead and serve an enormous amount of time in jail if that's the case. So we would ask that Your Honor give a bond, even if it's a high amount, that it's something reasonable, that if it can be posted, he can show to this court that he intends to return to court each and every time. Thank you.
The court has thought very carefully about this, and I'd like to make 2 comments. Of course, looking at the case that I have here today, the allegations here, as serious as possible. The allegations here, I use that word and I emphasize it, extremely violent. Mr. VanCallis has a felony drug charge pending in another county. And he has a long history in this court. My efficient clerk staff pulled his previous court contacts, 1, 2, 3, 4, 5, 6, 7, albeit all misdemeanor contacts. And one of them, the 10th one, certainly caught my attention when I looked at it. He was on probation for this court on a shoplifting charge. He twice disappeared on us for months at a time and got probation violations for disappearing and not reporting. Certainly not impressive when the court's considering the issue of bond. But given all those reasons, I believe it appropriate, I'm going to order Mr. VanCallis held without bond. Is there anything else to come before the court?
Nothing on behalf of the people, Your Honor.
Nothing, Your Honor. Although we have not received the actual physical charging document in this case, we would ask that the prosecutor's office provide us with a copy.
We'll turn one over immediately.
All right, very well. And if there are problems between now and our November 13th pre-exam conference date that address them to the court, don't hesitate to. I'll make myself very available if there's any issues about discovery or anything I can do to speed the process along. And state that to both sides. All right?
We thank you, Your Honor.
Your Honor.
Thank you.
Stand
Thank you,
adjourned.
Your Honor. You have a good day.
VanCallis, you're in the officer's custody.